The Aravalli Hills are older than Himalayas. They stop deserts from advancing, recharge groundwater and protect millions from pollution. But a legal definition, just a few lines on paper, could decide whether large parts of this ancient range survive or are slowly mined away. On Monday, the Supreme Court stepped in, paused its own ruling and asking a critical question: are we protecting the Aravallis or quietly shrinking them? In a rare move, the Supreme Court has put in abeyance its own November 20 order on the Aravalli Hills. The earlier ruling had accepted the centre's definition of the Aravallis, a definition that limited protection mainly to hills above 100 meters in height within a narrow belt. On Monday, a bench led by Chief Justice of India Surya Kant along with Justices J.K. Maheshwari and A.G. Masih said clarifications were urgently needed before such a definition could be implemented. Until then, both the earlier committee's recommendation and the court's own judgment are frozen. So why does a definition matter? The Aravalli range stretches across 4 states: Gujarat, Rajasthan, Haryana and Delhi. It is not just a chain of isolated hills, it is a continuous ecological system. Environmentalists warned that the November definition could expose large areas to regulated mining simply because they fall below a numerical height threshold. On Monday, the Supreme Court appeared to agree, calling the definition a structural paradox. The Chief Justice asked a fundamental question: if protection is limited to hills above 100 meters, does everything in between suddenly becoming non-Aravalli? The court raised a striking example. What happens if 2 protected hill formations are 700 meters apart? Can mining be allowed in that gap, even if it weakens the entire range? The bench warned that such restrictive demarcation could artificially create non-Aravalli zones, opening doors to mining while shrinking conservation all at once. The Supreme Court stressed that the ecosystem don't function in fragments. Mining in gaps between hills could disrupt groundwater recharge, worsen air pollution and accelerate desertification, especially in Rajasthan and Delhi NCR. If a regulatory loophole exists, the court said it must be identified and closed, not normalized. An exhaustive scientific determination, the bench said, is the only way forward. Importantly, the court flagged that the earlier committee was largely composed of bureaucrats. Now, the Supreme Court wants a high-powered expert committee dominated by domain experts, not administrators. This committee will examine all previous reports, identify areas that may lose protection, assess whether regulated mining would cause irreversible ecological damage. Until then, nothing moves. The Supreme Court has issued notices to the centre and the 4 Aravalli states. Solicitor General Tushar Mehta told the court that no fresh mining licenses are being issued. Meanwhile, Congress leader Jairam Ramesh welcomed the pause, calling it a setback to the centre's attempt to redefine the ecologically sensitive region. For communities living around the Aravallis, this is not a legal abstraction. It is about water in wells, air in lungs, and whether a natural shield built over millions of years survive another generation. By stopping its own ruling, the Supreme Court has chosen caution over finality. The question now is simple but profound. Will the law protect the Aravallis as a living system or reduce them to isolated hills on a map? The answer may decide the environmental future of North India.